Hello, everyone, and welcome. I'm Erin Daly, and on behalf of myself and Jimmy May, I'd like to welcome you to this segment of the Good Legal Stories series, a corollary to the Good Stories movement sponsored by the Normandy Chair for Peace, an endeavor based in France with international participation, whose motto is, "We will have peace on earth when we have peace with the earth." To that end, the Good Legal Stories series spotlights landmark environmental efforts from around the globe through the voices of those who worked on and decided the cases. Today, we are absolutely thrilled to have with us Hugo Echeverria, a lawyer from Ecuador who has been at the forefront of recent advances in the rights of nature revolution that we're seeing in Ecuador and elsewhere around the world. Jimmy, can you tell us more about our guest today?
I'd be happy to. We're really delighted to have Hugo Echeverria with us today to talk about really the way that rights of nature can be represented in court. He's one of the world's leading experts on that. Let me tell you a little bit about him. He has a doctorate of jurisprudence from Pontificio Universidad, an LLM from McGill in Montreal. He has 21 years of experience in environmental law and in rights of nature. He's a member of the World Commission on Environmental Law of the IUCN. He's also a UN expert on harmony of nature, and he teaches at various universities throughout Ecuador. One other point to note is that he was also a scholar in residence in environmental constitutionalism at Widener University, Delaware Law School, where Erin and I had the opportunity and the privilege of exploring these topics with him while he visited. He's here to tell us a great legal story about putting rights of nature into action. Hugo, tell us your story and welcome.
Erin, Jimmy, thank you very much for the invitation. I am very pleased to be here sharing my story with you. Well, like everybody in previous programs, I was trained as an environmental lawyer, and in that capacity, I had the privilege to live and work for 5 years in the Galapagos Islands in between 2010 and 2015. And my job was to see what was happening with criminal cases regarding the illegal fisheries of sharks, which in the Galapagos are absolutely protected. So my job was to see what was happening with the cases. You know, how many cases went to court, what of those cases got a conviction, and during that process, which lasted for about 5 years, I became very, very directly confronted with rights of nature, you know, and I began to see rights of nature, which were recognized by the Constitution of Ecuador since 2008, as a very powerful tool in order to raise procedural arguments, even much more powerful than environmental rights, because behind the logic of rights of nature there is an ecocentric foundation, which you don't find in environmental law, and it is truly a different idea, because nature becomes the party, nature becomes the victim, so it's not the object anymore, but actually the party, the subject of the case. So after my time in the Galapagos Islands, I moved back to my hometown, Quito. Quito is the capital of Ecuador. And by the time I came back, rights of nature have gone to courts in very different scenarios in Quito, in Ecuador in general. And the courts began to give answers to the plaintiffs. And all of a sudden, rights of nature became practical and enforceable. So when I came back, I fully concentrated my work on the new idea of rights of nature and how to put these wonderful rights into practice. And as we will mention later, I chose to go to use the tool of Amicus or Amicus Curiae for the reasons I will mention a bit later.
Hugo, that's a fantastic story, and it's the arc of your career, but it's also the arc of the development and implementation of this incredibly new right. Ecuador is the first country on the planet to recognize rights of nature constitutionally, and you've worked on among the first cases in human history to uphold that right. What do you see as the impact of these cases that you're working on?
Well, you know, in order to answer that, to check on the effects, the impact, I have to say that before rights of nature, I was a procedural lawyer. In my mind was fully procedural and focusing on criminal matters. But when I started to check rights of, you know, to address rights of nature, a whole new world of constitutional law gave birth in front of my eyes. And this was part, I have to say, part of my visit to your university back in 2016, because we addressed the issue of environment and nature, not only when I was there from a constitutional perspective, right? Back then, you just recently published your book on global environmental constitutionalism, which I read it and reread it, and I really liked it. So what I want to say is that I moved from procedural law to constitutional law, because that's where rights of nature landed in Ecuador. And then I began to explore the possibilities, the huge possibilities that constitutional law and constitutional procedural law would offer. And just reached to the conclusion that if you want to truly work on environmental matters, you have to move, you have to make a shift from the law to the constitution. And that's what I did. And the vehicle that I decided to use for that purpose was the Amicus Curiae. Having said this, between 2016 and 2022, now, some of the cases addressing rights of nature went from first level courts to appeal courts to the top court in constitutional matter, which is the Constitutional Court in Ecuador. And in 2019, the court decided ex officio that rights of nature needed a constitutional response. And the Constitutional Court selected several cases in order to provide an answer on what are the constitutional rights of nature. How are these rights different from environmental rights? Because many people tend to confuse these rights. And in practice, what does it mean for nature to be recognized as what we call subject of rights? I think in the common law, you called it as a rights holder. So by then I was just impressed and very glad to see that these rights, these new rights, were going to be addressed by the top judges of the country. They were not going to be addressed by the politicians in the legislative power, but they were going to be addressed by experts in constitutional law. And of course, I acknowledging that this is a very difficult task, because to be honest, no one really knows how to deal with the rights of nature, because this is a completely new field. You are not talking about corporations, you are not talking about physical persons, you are talking about non-human parties. And I decided that this was, this effort that was the Constitutional Court was about to make needed to be supported by the society. And I found that the role of Amicus Curiae was the best role for that purpose, to provide a juridical criteria that will hopefully help the judges make sound decisions, which are which we now have. Those decisions are in fact the very first one in the world, because if you check other courts, like the court in Colombia that is famous for its Atrato River decision, that decision is not really about rights of nature. Is like a combination, is a biocentric approach, whereas the approach that we have here in Ecuador is truly ecocentric, puts nature in the center of the juridical debate.
Could you tell us a little bit about that in the context of the mangroves case?
Yes. So far, the court has selected, in the ones that I have counted, 6 cases on to provide content on the rights of nature, and one of those cases had to do with there was a law in 2018. Ecuador issued a law, an environmental law actually, that it should have theoretically have to protect the mangroves. The mangroves are a very fragile ecosystem in Ecuador that enjoys constitutional protection. Ecuador has borders with the Pacific Ocean, and much of the coast of Ecuador has mangroves. But the mangroves have always been threatened by agro-industrial activities, namely shrimp farming industry, shrimp farming. So in this new law, this 2018 law, there was a provision that was not sound with the concept of rights of nature. And the provision was vaguely written and very ambiguous, that could be interpreted as allowing productive activities of industrial reach taking place in the mangroves. So that provision was challenged by environmental groups. They took using the legal institution of constitutional review, they took the law to the court, and they asked the court to review whether or not that specific provision on mangroves was in accordance with the Constitution. And 2 years later, after heavy deliberation, which included several a public hearing with several amicus curiae, myself included, the court decided that the provision on mangroves was indeed ambiguous and was not designed to protect the mangroves. And because of that, it was in violation with the constitutional standards of rights of nature. So what you have here is interesting, because you have an environmental protection provision being declared as not in accordance with the rights of nature standards. And the legal effect of that is that the court ruled that that provision was invalidated because it did not meet the constitutional standards on rights of nature. I submitted an amicus because I have a very strong connection with mangroves. When I was living in the Galapagos, I used to swim daily, on a daily basis, with my children in the middle of a wonderful little lagoon surrounded by mangroves. And this is, if you go to Galapagos, this is not surprising, but to some of the audience, the mangroves are also the home, it's like the nesting sites of sharks, of baby sharks. And you can actually swim with them in there at a very close, at a very near location from the beach. So I learned to not only to protect, but to love the mangroves. Even though I now live in the mountains, Quito is located in the middle of the Andes chain. I still have my head and my heart in the mangroves, and it was for me, and it was a must, something that I shall do to contribute with what the court was doing by providing legal inputs and transmitting to the court the importance of protecting the mangroves from a perspective of rights of nature. So when I saw the verdict, and I saw that the court concluded that the provision of mangroves was not in accordance with the constitutional rights of nature, I think that was what I was waiting to happen in my entire career. So I have to say I am satisfied now. That gave me a motivation for other 22 years in ahead. You're mute.
What a wonderful story, Hugo. Thank you for sharing it. And it's just heartwarming to hear how it started, that it started with an experience you had with your family among mangroves, and mangroves that way got into your head, into your heart. And here you are involved in pushing the law forward with what is fairly described as the most important rights of nature case in an apex court and in a high court anywhere on the globe. So thank you so much for sharing that story. It's another wonderful one. And on behalf of the Normandy Chair for Peace, thank you all of you for watching, and we'll see you next time. Thank you. Bye-bye.
I just want to say a final message. Okay. Because I know this is being watched by young generations. Two things, you know, rights of nature was a dream 13 years ago. Now is a reality. So dreams can come true in a fairly short period of time. This is the case of Ecuador, because rights of nature with the decisions of the Constitutional Court have come to stay. And now it begins a battle because not very many are happy with these decisions, you know. The miners are not happy, the shrimp farmers are not happy, but nature is happy now. And the second message is that you can do it by yourself. You are watching a solo lawyer. I don't have a law firm in my back. I don't even have an intern. I just have a very good software and my computer. And you can do it. I mean, little steps, maybe little contribution, but little steps and contributions can help achieve a greater goal. So go ahead and do it.
Then we'll leave that as the final word.
Thank you so much.